Hello, we're discussing here the free exercise clause and early tests. Now, we've just concluded two things that would be important for understanding of the cases and concepts we're going to discuss in this lecture. First, you should have listened to the lecture on defining religion, how the Supreme Court goes about defining what is religion. And there we talked about the belief-action dichotomy, a very important concept that runs through all of the free exercise jurisprudence. The other thing that's important to remember is our discussion at a previous time about due process and defining due process and the importance of neutrality, government neutrality, and the exercise of the police powers for defining what is due process. That concept of the requirement that states govern through laws of general applicability, neutral as to party, class, or interest, unless there is uh, a um, a reason not to, a justification for a non-neutral law related to public health, safety, welfare, and morals. That definition, that concept, has real importance for our understanding of how the Supreme Court has protected the free exercise of religion. These early tests in particular, they are balancing tests. Balancing tests have traditionally been associated with the common law, a common law jurisprudence, an approach to rights. The rational basis test is a balancing test, purely balancing. So you should keep those things in mind as we talk about tests like valid secular purpose test, various other tests that we're going to discuss. The court is attempting to find a way to apply government neutrality in the context of religion. It's important to remember. Okay, so this valid secular policy test first comes up in a case called Minersville School District versus Gobitis. This case was discussed in the chapter, and also you should have seen a lecture, or will shortly see a lecture, that talks about three important cases involving Jehovah's Witnesses. Uh, in this case, the Jehovah's Witnesses instructed their children not to participate in flag salute ceremonies that were conducted at the public school there in the Minersville School District. It's also important to note that the type of salute that was being done in 1940 was very different than the one that we do today. Today we have adjusted it. We put our hand over our heart, we take our hat off, put our hand over our heart when we recite the Pledge of Allegiance. In 1940, what was going on in the Minersville School District was that an individual would put their hand out in front of them, sort of pointing toward the ground, and as they said the Pledge of Allegiance, they would raise their hand up until the palm was kind of close to parallel with the flag. It looked very much like a Nazi salute. So I'm not sure that that was important at the time. I don't think the Jehovah's Witnesses were saying, hey, this is a Nazi salute, we don't want to do it. But it is a little bit unnerving to see some of these pictures and realize that in the 1940s, that's how we saluted our flag. In this case, the Jehovah's Witnesses children were disciplined for not participating in the flag salute ceremony. And the Gobitis, actually, this is another instance in which the court misspelled the name of one of the parties. But this family sued, and the state considered, the Supreme Court considered whether the state had a legitimate purpose for requiring this action. Now remember, from Reynolds, it was okay, the court said, for the United States, and I suppose by extrapolation for a state, to ban practices like polygamy, ban actions and practices, but not touch the belief. And here the situation was kind of the same, except that the state was requiring an action. It wasn't requiring the Jehovah's Witness children to believe this, but was requiring them to participate in this action. So did the school district have a legitimate purpose in requiring the practice? The court says yes, the state had a legitimate secular reason for flag salutes, and that reason was patriotism. Excuse me. It was patriotism. One of the most important functions of the state, Justice Frankfurter wrote, was to encourage patriotism and love of country, and that public purpose was enough to overcome the objections under the Free Exercise Clause. In Prince versus Massachusetts, also 1940, the Supreme Court said that states can regulate religious practices that might cause harm to children. This was a case involving inoculation of children as an objection to it because it violated religious practice. And so the Supreme Court says, here the Supreme Court actually is saying that states may regulate religious practices that could harm children as a legitimate secular purpose, right? That was an important legitimate secular purpose. People are free to believe what they want to, but if their actions or inactions end up harming children, the state can step in, the Free Exercise Clause notwithstanding. The court has also said that labor laws have a valid secular policy, and this is a case that we need to look at real closely here. So Braunfeld versus Brown, 1961, the court looked at a case here in which a state had passed a local ordinance that prevented businesses from opening on Sunday. We call these blue laws. And Braunfeld was a Jew who lived in the city, and his religious practice demanded, he was an observant Jew, conservative Jew, and his practice demanded that he not open his shop on Saturday, which is the Jewish Sabbath. So he's caught there with a real difficulty. He would have to stay closed 2 days a week, one to observe his religious practice, and the other to satisfy the legal requirements of the ordinance that he stay closed on Sunday, whereas his competitors, who were non-Jews, could stay open on Saturday, and the closure wouldn't conflict with their religious practice. So he sued, and the court says that laws that burden religion have to meet two criteria. This is sort of an expansion on the valid secular policy test. First of all, they have to be neutral. They have to have a secular end, a secular purpose. That's the valid secular policy part of it. And secondly, they have to be implemented using the least restrictive means. In other words, they have to be implemented in such a way not to burden the free exercise of individuals more than is necessary to achieve that important neutral secular end. So you would think then that Braunfeld had won his case, right? Wrong. The court said that blue laws have an important neutral secular purpose, which is to encourage rest and repose and time spent with family, and that the state had not burdened the religious exercise of Braunfeld by choosing Sunday, hadn't violated the least restrictive means prong of this test, because they had to pick Sunday, and Sunday was the best day for the majority of the citizens. There was really no religious component to it. Potter Stewart dissents in this case, and he says that Braunfeld is placed in a situation where he must make a, quote, cruel choice between his economic livelihood and his religious principles. That brings us to a very, very important case that's excerpted in your text called Sherbert versus Werner. The question there was, may a state deny unemployment benefits to a person whose religious beliefs preclude them from working on Saturdays? Now, this case involved not Jehovah's Witnesses and not people of the Jewish faith, but Seventh-day Adventists. The individual in this case had been fired after her company had changed their policy about working on Saturdays. She said that she could not work on Saturdays. She hadn't been required to work on Saturdays beforehand. But they changed the policy. She refuses to work, and they fire her. Furthermore, she applies for several jobs in which she was informed she would have to work on Saturday, and she was offered the job and refused to take it on religious grounds. So the question there is, excuse me, I'm sorry. So she applies for unemployment benefits, and she's denied because she was fired for cause and she had refused to accept suitable work where it was offered to her. She sues not to get her job back, but to get unemployment benefits. The court says, in answer to this question, may a state deny unemployment benefits to persons whose religious beliefs preclude them from working? The court says no. No. So let's get this straight here. So Reynolds, the court rules in favor of the state and the practice. Braunfeld versus Brown, the court rules in favor of the state against the religious practice and in favor of the regulation. But here in Sherbert versus Werner, the court rules in favor of the religious practice. The court says states must have a compelling interest to regulate on the subject of unemployment benefits or any subject related to work and religious practice. And the court says there is no compelling reason for the regulation being applied in the way it was to the individual who would not take work because of her religious beliefs. So here we see a shift, actually. Sherbert gives us a shift away from assuming that the state's regulation is constitutional, and the shift is toward the religious practice, toward the exercise of the individual right. Where have we heard this before? Well, over and over again, in particular in the due process section of the course, we've heard that there was a shift away from burdening the individual bringing the lawsuit and toward an assumption of unconstitutionality, shifting the burden for the regulation, justifying the regulation, onto the state or the government. We see that happening here in a religious free exercise case. All right, so in effect then what we get is a new test. This Sherbert test is kind of a new test. The court is going to balance the interests of the state in the neutral application of a law and creating order against the interests of the individual in the free exercise. And it's a balancing test in theory, but the finger on the scale is in favor of the religious practice, the free exercise. So the court says in Sherbert, the state must have a compelling interest, not just a legitimate interest like under a rational basis, but a compelling interest. Relate that to Korematsu. Right? In Korematsu, the court said that if you're going to take away someone's civil rights as a class of individuals, the government must have a compelling interest for doing so, and war was a compelling interest. Well, here, the state has to have a compelling interest to regulate the religious practice. And then the state must have implemented the policy to achieve that compelling interest using the least restrictive means. The means least restrictive to the religious exercise, to the free exercise. So actually then neutral laws could be struck down too, and in fact in Sherbert versus Werner, that was a neutral law. There was no effort on the part of the state to penalize Seventh-day Adventists, but that ends up being what happened, and despite the neutrality of the law, it burdens religion excessively and is struck down. So the question here is, will the valid secular policy test, the Sherbert test as we come to call it, will it favor the individual? I made a mistake there actually. The valid secular policy test is just the first part, really, the first prong, and then Sherbert comes along and adds compelling interest, and then adds a second prong called least restrictive means. So will this always favor the individual? Well, let's see. Thomas versus Review Board of Indiana. Person was required to make a similar choice as in Sherbert. Court rules in favor of the religious practice, the free exercise. Bob Jones University. Well, the court applies this standard and determines that government has a compelling interest, and that interest is in combating racism. Bob Jones University was receiving federal funds, but then also had a number of policies that outlawed that banned interracial dating, and also had a very strict admissions policy that seemed to burden certain races than others. And the Supreme Court says that government's interest in combating racism is compelling enough to uphold the policy that took away federal funds for universities that practice certain forms of racial discrimination. And furthermore, the court said not getting that federal money doesn't stop the university from practicing its religion. And in fact, they were right. Bob Jones University exists today, despite the federal not getting any federal funds. It kept its policies because it's a private institution. It just simply doesn't take any federal money. So that's interesting then, because in Sherbert, rules in favor of free exercise. Thomas, rules in favor of free exercise. Bob Jones University, same test, but rules in favor of the government. Suggests the standard might be in jeopardy. I'm not exactly so sure, though. We do, though, the text talks about the downfall of the compelling interest standard, and more we see the pendulum swinging away from the free exercise of religion and toward the government regulation. U.S. versus Lee, government has a compelling interest in collecting Social Security taxes, so you don't get to exempt yourself from those. But why is this different from the situation in Yoder? You might have read about that in the text or heard about it. It involved a state law that required all children in a state to attend public school until the age of 16. But a particular sect of the Amish did not want to educate their children until that age and wanted to be able to remove them from school beforehand. The court says that government doesn't have a compelling interest in requiring education for children in a public school setting, and that in fact the transmission of values is so central to the Amish culture that it would cease to exist if this neutral law was applied without exception to them. So how is it different than to say that my religious practice requires me not to pay Social Security taxes or get Social Security benefits? That's a good question. Goldman versus Weinberger. The court says that the military has a special interest in subordinating individual interests to discipline. Now, this involved a serviceman, Goldman, who wanted to wear a yarmulke under his regulation military hat. But the military had a requirement that anyone who adorned their uniform in ways that were outside the required practice were violating Uniform Military Code of Justice, and they were committing an offense, and they wouldn't be required to wear religious symbols or things like that. And so Goldman sues, and he sues Caspar Weinberger, also of the Jewish faith, who was Secretary of Defense under President Ronald Reagan. And the court rules in favor of the government, says that the compelling interest, the special interest, is in military discipline and order. So is this a break in precedent or a special case? We're not sure, but it sure seems like more and more the court is finding reasons to uphold the government regulation against the free exercise. Yeah, so the point is that Congress has passed a law allowing neutral and conservative clothing, and the Supreme Court has upheld this neutral law even though it burdens religious exercise. Okay, I think we're going to stop there, and the next lecture we'll pick up with the Rehnquist Court and the Sherbert test. Thanks for listening.